Okay, Erica.
All right, good afternoon, everyone, again. So happy that you're back with us. This program is going to be very exciting. It's a view from the bench, guardianship and supported decision-making, issues and challenges, practices, and reform. As many of you know, and there have been a lot of efforts over the past several years to reform Article 17A guardianship statute, as well as pass new legislation on supported decision-making in New York. And we thought this was an opportune time to invite these esteemed surrogate court judges to help us understand how court practices may be changing to accommodate for this shift in thinking, and how best to support individuals with intellectual and developmental disabilities in the least restrictive manner. We feel very fortunate and privileged to have with us today 3 surrogate court judges from 3 regions of the state who will be discussing their respective views about guardianship, supported decision-making, requirements for in-person versus virtual court appearances and hearings, and how their court practices and processes will or have already changed to meet the changing trends and ways of thinking. We have with us today Tara Ann Pleat. We're very thrilled to have her here as our moderator. She is a member of our state guardianship committee. She's going to be moderating the program. And Tara, just to give you a little bit of background, Tara has a very nice bio that's on our program online, so that you can see that on our website. But just to give you a little bit of information, she co-owns the law firm with Bulsensky and Pleat. She practices in the areas of special needs, estate planning and administration, traditional estate planning and administration, long-term care planning, and elder law. Tara has been the chair of the Elder Law and Special Needs section of the New York State Bar Association, and is the immediate past editor of the Elder and Special Needs Law Journal, a publication of the New York State Bar Association. She is dedicated to the practice of disability and public benefits law. So we're very happy to have Tara with us and to help moderate this wonderful panel today. So Tara, I'm going to let you, before we get started, I just would like to ask everybody to please make sure you're muted throughout the workshop, and also to please write down or put your questions in or comments that you would like to have the judges and Tara address along the way in our chat box, okay? Because that's really helpful for us. All right, thank you.
Thanks, Erica. So yeah, if you have any questions that follow the discussion that's happening today, feel free to put them in the chat. I'm monitoring that, as is Erica and some of the other members of the staff here. Just as a preliminary, I want to take a minute and introduce the 3 surrogates that we have with us today. And as Erica mentioned, from different regions of the state with varying practices and populations. So we're both grateful for their time and their willingness to have a discussion with us about 17A guardianship, the reform, supported decision-making, and overall practices that are happening in different areas of the state. I'm just going to introduce everybody in alphabetical order. That's the easiest way for me. So the first surrogate that I'll introduce is Judge Gelati. He's been serving as the Oneida County surrogate since 2009, and he also acts as a Supreme Court justice. What that means is not only does he hear Article 17A guardianship proceedings in his role as the surrogate, but he also presides over Article 81 guardianships in Oneida County. So he has the perspective coming from looking at both of those different types of guardianship proceedings and their differences. Judge David Guy, who is the Broome County surrogate judge and has been since January of 2011. Judge Guy sits supreme as well, and he handles the mental hygiene Article 81 guardianship matters throughout the 6th judicial district. So again, both forms of guardianship are being brought before Judges Gelati and Judge Guy. Last but not least is our surrogate from Westchester County, Brandon Saul. Judge Saul has been the surrogate in Westchester since 2015. Many of you folks know that the Westchester area has sort of been the hub for the beginnings of supported decision making through the Westchester ARC and its relationship with CUNY and Hunter and New York's supported decision making pilot. In addition to that connectivity, Judge Saul is a member of the statewide Alternative Dispute Resolution Committee, mediation, something that is often sought out in guardianship proceedings, both in Article 81 and newer so in Article 17A. So again, we'd like to welcome Judge Lou Gelati, Judge David Guy, and Judge Brandon Saul, and thank them for their time and their insight this afternoon. Decision-making for individuals with intellectual and developmental disabilities is the reason why we're here, right? It's the reason why we do this program every year and why we have this training. And over the last several years, you as attendees have heard from a variety of individuals, myself included, about the status of guardianship reform, about New York's pilot program on supported decision-making, and the overall interplay with the Medicaid-funded service delivery system under the Office for Persons with Developmental Disabilities. And that context is what's going to inform our discussion today. For those of you who don't know, I didn't participate this morning, so I'm not sure if there was any discussion about this, but New York State passed a supported decision-making statute in this past legislative session, and it was signed into law by Governor Hochul on July 26th. That legislation, and you're going to hear more about that in the next session from the author of that legislation and the author of, I shouldn't say the author of, but who will participate quite heavily in the drafting of the proposed regulations. But that legislation gives OPWDD until July 26th of 2023 to develop the regulations around what SDM is going to look like and the facilitation process. And as a result of that need for a regulatory framework, that statute will become effective 90 days after those regulations are issued. So we expect sometime in the fourth quarter of 2023 will that be an effective statute. So just some baseline information, but as many of you know, supported decision-making is already happening. Agreements are already being facilitated. And there is a lot of movement in that area. The ARC New York is involved, as you all know, as a stakeholder in both the development of those supported decision-making regulations. We have the insight and the, I don't want to say luck, but the insight and the good fortune to have Nancy Sicoso from Westchester ARC, who is both participating today, but also has a very in-depth understanding of that supported decision-making process. And a former member of our guardianship committee. And although she's a former member, she's still active and helpful and wonderful in providing us insight on how those processes are going forward. And the ARC is also involved in 17A reform, notwithstanding this supported decision-making statute being enacted or signed into law. The ARC continues to participate in discussions around guardianship and the current proposed modifications to Article 17A. There's 2 bills that are currently out there, one from the Office of Court Administration, one from the Law Revision Commission. And while it's been quiet on that front, both probably due to COVID and due to the dismissal of that disability rights lawsuit we talked about several years back, the issue is not dormant, and there are a lot of discussions happening behind the scenes. And as more and more focus is placed on decision-making for individuals with intellectual and developmental disabilities and the processes that take place to get us there. We expect we're going to be talking to you all about that over the course of the year, and certainly next year at our annual training. The ARC continues, as you all know, to update information about guardianship, alternatives to guardianship, and educate the chapters and the staff and the volunteers around that decision making. So just wanted to set that context and thank all of you for doing the things that you do in your chapters. If you stayed on to watch the video, the Legacy of Love video, it really was beautifully done. If you didn't, I would commend you to watch it. Really lovely and powerful in how different families come to approach this process and the reasons why. And I think that's important for everybody to hear. So with that context, I'm going to start off by asking the surrogates, and I guess just because we're not all sitting in a room, judges, I'll start with Judge Saul and then go to Judge Guy and then Judge Gelati for the first question, and probably go that way all the way through, unless the natural conversation takes us elsewhere. So Judge Saul and then Judges Guy and Gelati, I just ask for you to explain to the participants here how you've seen the Article 17A practice in your court and your geographic area, your region, change in the last 5 years.
Okay, well, first of all, thank you for inviting me here today. So Westchester has about 1 million people now, and you know, we see a lot of 17As. Today on the calendar, I probably had 8 to 10, and that's basically what I have every other week. I have my calendar for guardianships every other week, so we're probably seeing 20 a month. The practice, though, has changed a lot. I think when I got here, which was 7 years ago, we were basically just rubber stamping whatever the petitioners sought. And now, you know, we're looking at these much closer. So our court attorneys will call these matters in after the petition's filed, obviously, and we'll conference it with the court attorney. And if we think there's an alternate to guardianship, we're going to explore that with the petitioners, and we've had good results. You mentioned that Nancy is on this Zoom, and she's been instrumental because we send people to her, to ARC of Westchester, to see if the respondents would be good candidates for support of this decision making. So in sum, it's changed a lot. We're looking at these much closer. I know that issuing a 17A guardianship is a drastic remedy for some cases, and we're trying to, you know, make sure that, you know, people that don't deserve a 17A don't get one. So that's what we're doing here in Westchester.
Judge Guy.
Thank you. And like Judge Saul, I appreciate the opportunity to be with everybody this afternoon and talk about this area. I sit in Broome County, which is Binghamton, New York. My county is just went below 200,000 in the most recent census. So my numbers are very different from Judge Saul, where he's got, as he says, 8 or 10 every other week. We'll see 1 or 2 a month. And I went back to check our numbers, and that's kind of a steady pace over many years until the COVID pandemic hit. And then, of course, we saw a drop, and some of that was, I think, families not being focused on other things. Some of it was also the challenge was we had sort of getting cases in the door for a while. But in 2020, 2021, our case numbers dropped by probably a third. And this year they're back on track to what I'll call it a more historical level. The other thing that has changed post-COVID is that initially all of our proceedings, guardianships and otherwise, converted to being online through Teams, which has become a better product as we've used it the last couple of years. But we have transitioned back to largely in person, but we have left open the possibility for guardianships and other cases that matters proceed virtually. And while both in the context of a 17A and the Article 81s I do, my strong preference is to meet people in person, it is, I think, fair to say that for many families and for many respondents, it's a more comfortable situation to remain in their house for folks who have the ability to technically to do that. And so I think that I don't think my ability to get a sense of the people I'm dealing with has been compromised by the change to virtual. And my perspective is that we'll probably stay that way and give people that continuing option to avoid the challenges of getting into court. But leaving open the possibility that in the right cases, we'll still bring people together in person to go forward. And so that's kind of the change we've seen. We're going to talk later about supported decision-making and referrals there, so I'll leave those comments. Suffice to say that my court is not as actively exploring that option with folks as Judge Saul's court, but the topic still comes up, and we'll talk later about how we do that in our area.
Thank you, Judge. Judge Gelati?
Yes, can everyone hear me?
Yes, sir.
A little paranoid about that because in our prep meeting, I was having some audio problems. Let me start by thanking the organization for inviting me to speak. As I told Tara recently in another seminar that we were involved with, I learn a lot from being able to participate in these types of symposiums. I also want to give a shout out to Francesca Bevavino, who's the guardianship coordinator in our Utica area. She does a wonderful job helping people with these cases. In cleanup hitter status here, let me say my county is very similar to Judge Guy's, a little bigger. We're about 230 to 240,000 people. I average about 40 to 50 17A cases per year. What I've noticed since 2009, when I first came here, there were a lot of private attorneys who were involved in prosecuting these cases for parents or for petitioners. I find that virtually most of them now are parents or petitioners petitioning on their own. That might be a function of the fact that the Office of Court Administration has put up a DIY or do-it-yourself application, which a lot of people use. As a result of that, we've had fewer lawyers in our area practicing in this area, which in turn has led to fewer lawyers willing to serve as guardian ad litems. Self-represented people aren't big on wanting to pay guardian ad litems, so it's hard to recruit them when I need them. That's been a problem. And the other thing I wanted to mention was, for some reason, most of the cases that I seem to get now that are the most difficult, most of them, first of all, are developmentally disabled, and they're on the autism spectrum disorder, and they're the most difficult to handle. The other change, of course, is the obvious one. A member of our association, the former surrogate of Manhattan, Kristen Booth Glenn, who's a driving force behind supported decision-making in New York, back in 2018 called me when I was putting together the program for our surrogate association, and she said, "You've got to let me do a program on supported decision-making." That's what made me sensitive to the whole issue. And we'll talk about this more as we go on, but that's why in certain cases I make the inquiry about utilizing supported decision-making.
So Judge Gelati just indicated that currently the vast majority of the applications that come for guardianship to his court are pro se, meaning no counsel is involved. Judge Saul and Judge Guy, is that your experience as well?
Well, I think in Westchester, we're seeing maybe 35 to 40% have counsel. So I think that, my percentage may be a bit higher. We're an affluent community. And And so I think that that percentage would be about right.
And I think we're certainly less than 10% with counsel. And like Judge Gelati, we had a couple practitioners in particular in our community who were active in ARC and did a lot of presentations in the area and did a lot of these kind of cases. I honestly don't know whether they were doing them pro bono or not. One gentleman in particular, I think, was. So those folks are both retired now. And so we don't have a lot of practitioners in the area. We'll talk about guardians ad litem later too. And my experience there is varies from Judge Gelati's. I have an advantage that he does not in Utica. So we'll talk about
Yeah,
that.
Judge Guy, I'm going to jump there right now because it seems like a natural question to follow. So, and Judge Gelati, just to start with you. So in your courts, you have to appoint a private practitioner if one is willing to serve. So who do you typically try to appoint in those cases? And do you have the ability at all to appoint MHLS, Mental Hygiene Legal Services, for those of you who don't know what MHLS is, although I suspect you all do?
So mental hygiene legal service, by the way, my understanding divides itself into 4 offices based upon the 4 judicial departments. I'm in the 4th judicial department. Judge Guy's in the 3rd judicial department. The 3rd judicial department has a wonderful director, Sheila Shea, who I understand affords guardian ad litem services in courts in the 3rd district. In the 4th district where I am, they only appear where the statute says they need to appear in cases where someone's in a mental health facility. And in those cases, they'll give me a report as to whether or not they believe the 17A guardianship is in the best interest of the ward, but nothing further. I find it really, really frustrating that we have Article 81, which affords counsel to an AIP, an alleged incapacitated person, statutorily affords counsel. But you get to Article 17A, which is a sledgehammer, right? You can't tailor a 17A guardianship, and yet there's no right to counsel. And I have a very, very difficult process getting guardian ad litems. I'm down to only begging for them in cases where I absolutely need them. The way I read the statute is in cases where a parent is applying or parents are applying or one parent with the consent of the other, I could simply hold a hearing myself and not appoint a guardian ad litem. And that's often what I do in the so-called easy cases. We had a practice here in this court before I came here where the surrogate was not releasing a decree of guardianship unless the guardian ad litem was paid. I had to obviously end that practice because I don't think that's fair to the parents or the ward. But I have a difficult problem getting them paid. When I do appoint them, I usually, as Judge Saul said the other day, try to find a case where I can, a nice case where I can give them as a guardian ad litem in surrogate's court to have them get some remuneration.
Judge Guy?
That's, I'll just pick up on Lou's last point, that technique of getting somebody to do a case where there isn't available compensation and then being able to appoint them on another case where you can is a kind of an unspoken quid pro quo that we use sometimes. But in a 17A, I'm incredibly fortunate. Wherever I need to appoint a guardian ad litem, I can appoint mental hygiene legal service, and I do. So we typically will always appoint them when it's apparent that the ward is in an OPWDD facility, which is not very common with a 17A because many of our 17As are people who have just become adults. Most of them are still living at home. But in other cases where I have a lack of consensus between parents or other factors that motivate me to get an independent look, I do appoint mental hygiene. And while the statute allows them to be compensated, I honestly don't remember a situation where the circumstances of the family warranted my asking mental hygiene to submit an affirmation to be paid. So it's really a service that in the surrogate's court in my county is really without compensation. And even where they are paid, the rate is trivial. So one of the, and I share Lou's concern about the relative availability of counsel in a Article 81 versus 17A. One thing I will point out is that in a supported decision-making situation, and again, we'll talk more about that, that anticipates a facilitator who is a third party or somebody who is going to facilitate the process in the way that an attorney can on behalf of parents in the 17A. So STM as a process anticipates and in fact requires a facilitator. So that's one of the challenges of supported decision making is the time and the complexity, but it does, one of the big advantages is got somebody to steer the process in the way that an attorney or a guardian ad litem would.
Judge Saul?
Okay, first I want to point out that now we can give CLE credits to guardians ad litem that are working pro bono. So at least there'll be something to reward these GALs. But with respect to our court, we've had to change a lot in the past few years. We were fortunate to have mental hygiene handle all of our matters. And in our district, I guess, because of budget restraints or constraints, they stopped that process and will only serve as a GAL in matters where someone's in a facility. So we were kind of stuck, and we then decided to appoint GALs like we do in the typical surrogate courts proceeding, where the GAL would actually charge the petitioners for the work that was done. Unfortunately, or fortunately, we got a lot of pushback on that, and we had to change our model. So what we ended up doing is doing a training course just for GALs in 17As. And actually Judge Glenn was kind enough to help us with that program. And so we trained a whole bunch of new people that weren't necessarily on my list for the typical surrogate court appointment. And they have served actually without compensation in many of my 17As. I don't appoint a GL in all cases when there's really no issue and we're rock solid that a 17A guardianship is warranted. We're not appointing GALs on those. But when there's some gray area or we want to look further into this, then we do appoint a GAL, and they have been working pro bono and hopefully be happy with the CLE credits. And I tried to give other appointments that would have compensation involved with them.
So Judge Saul, in Westchester County Surrogates Court, do you utilize those guardians ad litem, or you referenced conferencing before? Do you utilize that process to determine? I guess I should ask this in a different way.
Well, there's a question in the chat that Catherine Conway asked, and basically I think that's the same question, in that she says there are some that surrogates may think it best to require trying out SDM before accepting a petition for a guardianship. We don't do that because we first want to conference the case and find out if that individual would be a good candidate for SDM. So that's how we do it first. We require a petition to be filed. In our court, the clerks handle that aspect of it, and they don't have the expertise to look at these matters and make a decision at that point whether supportive decision-making is the right alternative to guardianship or not. So we leave that to me and the court attorneys to figure out whether it would be advantageous to pursue supportive decision-making.
And we do a similar process, but maybe less structured than Judge Saul. All the 17As come through my chief clerk, who will review the files, and then if there's any issue, and she has great experience, and I defer to her judgment almost completely. But if there are cases where, as she works with folks to get their documents in order, et cetera, she perceives a guardian ad litem is appropriate, or as Brandon said, if it's not rock solid for 17A, that would be when we would explore other options, or in the first case, appointing a GAL. So we kind of pre-screen them in that same way too.
Judge Shalati, sorry.
No problem. Yeah, I like to call it triaging. As you know, the ward has to be cited in a 17A case. That's the first day they appear in court, either virtually or in person. And that's when I try to engage them in meaningful conversation if possible. And that triaging kind of leads me to determine whether I suggest to the petitioner whether they've considered supported decision-making. Sometimes it's obvious that it may not work, although I know proponents of supported decision-making, I think, are of the belief that it can work even in cases where there is a severe lack of capacity. The other day I recounted this to the elder law section, so I'll recount it to you. I had a case in early August that I asked the mother to try supported decision-making, which she agreed to. That followed me having this conversation with her son, who had turned just 19. I asked him, I said, hey, do you feel like you ever make decisions for yourself? Sure, I do, he says. I said, can you give me an example? He said, yeah, as a matter of fact, I just opened a bank account. I said, where's the money come from? He says, well, I have a job. I go, well, what's your job? He goes, I design websites. You do? Yes. And so do you put your money in there? Yep. You decide how to spend it? Yep. And I said, do you make medical decisions? He goes, yes, I do. I go, can you give me an example? He said, well, I can tell you I order my own medications when they need to be refilled. I go, what do you take medications for? And he said, I take it for autism and ADHD. Then I thought I'd try a really hard question, which was, what are the medications that you take? Well, he told me. So then mom comes on and says, basically everything he told you is true. She said, he didn't tell you that he decides his work hours. He only decides to work 2 4-hour shifts a week on his own. He doesn't tell you that the money that he has, he spends on unnecessaries instead of necessaries. And she concluded by saying, even though he has this ability, he doesn't advocate very well for himself. The point I'm trying to make is I had heard enough where I thought, here's someone who could probably, retain his rights and benefit by supported decision-making. And I sent them off to supported decision-making of New York, who readily has engaged him in the process. And so far, it looks like it's going smoothly. We'll see. And
let me add to what Judge Lottie said, if I might. When Judge Glenn first got involved in supported decision-making, she put a committee together. I want to say this is probably 2015. And she was kind enough to invite me to be part of that. So I became aware of supported decision-making early on. And as Lou said, she also, as an active member of the Surrogate Association, was always talking about supported decision-making and has given us at least 2 or 3 presentations on it. So in my county, I'm probably more familiar with supported decision-making because I'm outside of the metropolitan area than anybody. So I always talk to folks when they come in and say, have you heard about this concept called supported decision-making? The reason I know I'm as familiar as anybody in the county is probably twice in a year, I'll hear somebody say, oh yeah, we've heard about that. And so when they haven't, I kind of reviewed the concept, and I reviewed in the sense that supported decision-making is like the guardianship we all would want to have if we were the ward, and we would want to have as the parent or supporter of somebody who's got one, which is, taking that person's determinations and wishes into consideration and working with the person to make the decisions. SDM is a legal structure like 17A is, and the question is, how do you engage in the process to get there? And with very, very few exceptions, unfortunately, one that I had in front of me a couple of weeks ago, the petitioners, largely parents, understand conceptually and are and want to manage their 17As in that way. And so, you know, sport decision making is a 17A as it ought to be run.
Judge Shalati, Judge, you're talking, but it's low.
Oh, I'm sorry. Can you hear me now? How about now?
Yeah, you gotta like shout.
I don't know if
There
Judge
it
Guy, I don't know if Judge Guy's experience or Judge Saul's is the same, but oftentimes when I try to explain the process to parents who are petitioners, they invariably say, and I believe them, we already include him in trying to make decisions. So I don't know why I have to go to a formal process. We certainly take his stated preferences into account. That's some of the resistance that comes up.
One of the questions that I think probably lots of folks here would be interested in knowing the answer to is, do you consider, given the context now, and Judge Shalati, you may have already answered this earlier, but for the three of you again, do you consider that you have the ability now to tailor 17A guardianships, whether it be time limited or adding some type of statement that the guardians agree that they will take into consideration the wishes, the needs, and the desires of the ward in issuing them? And I'll just preface this by saying, on the time limited side of things, the idea that at age 18, lots of stuff is going on for a number of these young individuals, and it is when advocacy within the service delivery system really starts to become a lot more important. And we know, and we can talk about this, we should talk about this, but supported decision-making doesn't happen overnight. It can take 6 months, it can take 9 months, it can take 12 months. It cannot work after going through the process. So is there a belief, or even, belief might not be the right word, but do you in your own courts, or have you heard of other courts around the state time limiting or otherwise tailoring so that there isn't that gap in time?
Yes. Judge Kelly mentioned that last week at our conference before elder law, that in fact he has been tailoring them. I think he'll put the decree in effect for a period of about 2 to 3 years, send them to supported decision making, then bring it back for review. I know that Judge Saul and Judge Guy will have more to say about this. In follow up to what you said, a person that carries that guardianship label, since it's so recognized and it has so much gravitas, it's really recognized by everybody, and all service providers look for it, whether they're going to give you healthcare services or whether they're going to give you OPDD services or public welfare services. They're looking for you to be the guardian. And I agree with you that at 18, there's a lot of things you need to get done. So I think it's a great idea to give the guardianship, put a time limit on it, and review it 2 or 3 years down the road. And I'll leave it to Judge Guy and Judge Saul to comment.
Well, we actually are doing that now, but I just rendered a decision last week by the name of Reed DKH, and I basically terminated a guardianship. And what was interesting here was that I granted the guardianship in October 2015, and now the respondents at NYU graduate school doing really well, and the parents came back and they petitioned to terminate the guardianship, which we granted in the decision. But had we been doing the term limited guardianships, back in 2015, we would have avoided this situation. But I was happy that we're able to terminate it. But we're doing that now on a regular basis when the need arises.
Thanks,
And
Judge.
I have not done any term limited guardianship, but after the discussion in the last few weeks, including the case that Judge Saul just mentioned, I think that's a practice I'm going to start to adopt in appropriate situations. Again, there are some cases where it doesn't appear to be the appropriate result, but where there's a question about somebody's capability going forward, I think that's an excellent idea. And I think the practicality of having something in place that allows kind of seamless continuance of the care, the services, the financial assistance that a young person who's got some disabilities or some issues can be able to continue that, so there's no interruption in that while other issues are explored. I think time will tell whether folks who are sent away by me or Judge Kelly or others saying, go see the supported decision-making folks, are, and then they come back in 2 or 3 years. Some of those are going to say, and hopefully not a majority, are going to say, we just never got around to doing that. So I don't know. Well, but I think that is a good idea. I have issued tailored 17As, doing a lot of Article 81s, which are all tailored. And there's cases across the state where folks have tailored 17As. So I've tailored them for other reasons than just temporal limitations. And my tailoring has been not so much related to the specific issues of the ward as the dynamics of the family within which they reside. But I think there was a lot of talk about tailoring 17As. That's kind of faded away. Supported decision-making would certainly be an alternative to doing that.
When Judge Gelati tells that story about his petitioner in his court, I mentioned this at a conference last week. That's something that just kind of slaps me in the face. As a lot of you know from hearing me talk in prior years, I now have an 18-year-old son on the autism spectrum who spends all of his money on Godzilla figures. Fortunately, has the capacity to sign a HIPAA authorization so that I can interface with his healthcare providers, and he's allowing me to facilitate service application for OPWDD. But if I left that to just him, it wouldn't happen. With all of the support and all of the I don't want to say pushing because that doesn't sound right, but that's kind of what it is, motherly influence, right, to move forward. It doesn't always happen because you can't guardianship, as we've talked about in the broader group that's on this meeting today, and in smaller pockets, it doesn't give you the ability to control behavior. And so, when you have petitioners come in and you're conferencing or you're doing an informal before you're on the record, let's say, how do you have those conversations with families? And do you find that not just supported decision making, but have they been exposed to any alternatives? Like, do they know that their 18-year-old can sign a healthcare proxy power of attorney if they have the requisite capacity to do it, or a HIPAA authorization? Do people come in with that knowledge, or do you find more and more people say, I was told I have to do this from a doctor's office or from the school district or from my neighbor or what have you? Judge Saul, you want to start?
Well, that's really what we hear all the time, that the schools are telling people that they must come in and do the guardianships. And, so what we're doing is, when they come to court and it's not before the petition, unfortunately, they have to file the petition and then we get involved. We then try to educate these people as to alternatives to guardianship if we believe that they should investigate that. I wanted to mention that Judge Titone in Richmond County, otherwise known as Staten Island, I believe he requires all petitioners to listen to a video describing alternatives to guardianship before even the petition, I think, is filed. And they're online. They're on, I think, his court website. But they're very well done. And that's something that Westchester is going to be looking into. We got slowed down with this because of COVID, but that's something that, I think is important to educate people right away as to alternatives to guardianship.
Judge Gelati?
my experience is the same as Judge Saul's. A lot of people have no idea about healthcare proxies or powers of attorney. In fact, I've added this question as part of the triage process for the petitioners. And it's a simple question. Why do you feel you need guardianship of your child or whoever? And most of the time, the answer is because all of a sudden, even though I've been taking such great care of my child for all these years, my doctor's office won't deal with me anymore. The emergency department won't deal with me anymore. His educators won't deal with me anymore. And they all told me I had to come and get guardianship. So my experience has been the same as Judge Saul's.
Judge Guy?
Very similar to Judge Gelati and Saul. I will say that I've had a few cases where, because of long-term relationships between families and medical providers, the medical providers have, I guess, albeit on an informal basis, continued to work with families. And one of the most difficult cases I had, it actually came up in the context of an Article 81, not a 17A, and that's because the mother and the daughter had genetic issues. The mother just had personality issues. And they were kind of a different team, but they worked well together and they had a good relationship with the daughter's doctor. So they got this girl until she was literally 21. And then the pediatric practice said, we're sorry, but our policy is we don't continue patients after they're 21. So they had accepted the mother's ability to informally support and make decisions for her daughter. And I've had other cases like that. The challenge was in this case with the mother and daughter that because of the mom's issues, things kind of, when she had to go find a new doctor, their whole situation exploded and fell apart. And then DSS got involved and ended up bringing a guardianship case relating to the daughter because they didn't perceive the mom's ability to take care of her daughter. The reality was that her daughter was 21, suffering from a genetic issue that 1 in 1,000 people who have this genetic issue live to age 21. So her mother had been doing something right, obviously, but it was a very, very difficult case. But yes, largely it's the support group of the family, the school system, the medical providers say, go get guardianship.
Okay, so one of the I would say feelings. So feelings aren't facts, right? But they're feelings, and they come up sometimes in talking with families who have attempted the 17A process, and for one reason or another, whether it is pushback from a court clerk, pushback from an appointed guardian ad litem, they were pro se and then they choose not to be anymore because they feel like now they're in this adversarial position with their child, which was never the intention coming into the proceeding. When you are, or when your staff is having those conversations with families, whether it's through this informal process or if it's after the appointment of a guardian ad litem, how do you find those discussions to go? Do you find that you have families that are open to the fact that there are alternatives? Do you find that there are concerns with the view that these folks, just from my own vantage point, you don't learn enough about a person from 2 physicians' affidavits in a 15-minute meeting, right? You just don't. And that's effectively what your guardian ad litems, if you have the luxury of appointing them, and that's exclusive of MHLS. I think that for the courts that have the luxury of appointing MHLS, you have a different level of expertise and I think empathy because of the role that MHLS plays throughout the state in various different proceedings. But I'm just curious if you've either sensed or experienced pushback from the families where they feel like, what do you know? How is it that you're sitting up there telling me that this is not the right decision for for my child.
Well, I'll start, I guess, but my court may be different than Judge Guy or Judge Gelati in that, you know, I have court attorneys actually that will meet with the family when the petition is returned. And so one of our court attorneys who's in this seminar, Joy Bean, has a real passion for guardianships. And on a side note, she's been very instrumental in redesigning, you know, our guardianships and how we look at them. But I believe that Joy and all the court attorneys that are conferencing have a very soft touch and are not making matters worse and are trying to just educate these families as to least restrictive alternatives to guardianship. But at the end of the day, you know, we have to protect the ward. And if a guardianship, if a 17A doesn't fit this particular person, then, you know, we're going to do what we have to do because our interest is making sure that the ward is protected. You know, these 17As, as we've discussed, they're all or nothing. And as I had mentioned the other day when we spoke at another seminar, Claude Pepper, who was a congressman and a U.S. senator from Florida, said many years ago that the most punitive civil penalty that could be levied against an American citizen, with the exception, of course, of the death penalty, is a guardianship. So, you know, we take it very seriously, and we may, you know, not see eye to eye with what the petitioners want, but at the end of the day, I believe our duty is to the ward, so to speak.
Judge Gelati?
I can recall a couple of cases over the last 13 years where if there was disagreement between the guardian ad litem and the petitioning parents, I had a couple of cases where the parents ended up withdrawing, and I often wondered whatever became of that ward receiving services or who was making decisions for them or not. And then the other area that comes to mind, not completely related, is these situations. I get a lot of cases where it's bio mom, now married to stepdad, and she petitions to have herself and stepdad named as co-guardians, or stepdad is the standby guardian. And bio dad, of course, unless he can be found to have abandoned, has to be cited, and oftentimes puts up a big fight about stepdad being co-guardian or standby guardian, and the guardian ad litem ends up weighing in on one side or the other. And again, it takes a lot of smoothing out at times to keep people in the process.
I've had many cases, unfortunately, like the case that Lou just mentioned, and I have one of those cases pending right now in the context of an 81. It is a person who, from a diagnostic perspective, would qualify for 17A, but his bio dad went the Article 81 route, I think partially because his bio dad's attorney was involved in another Article 81 with me, in which the issue was the visitation of a parent with her two daughters. And we went up to the appellate division a couple of times and sort of developed the law in that area. And this was a visitation issue for this child in this case. And so I think because the attorney had experience in this other case, she brought it that way. But those are the most challenging cases. And I do find myself reminding folks that the issue is, and the responsibility of the court is, to the ward, not to the parents. And it's very difficult. And you know, like Judge Saul's staff, and I'm sure Judge Gelati's, our staffs have a very light and kind touch with folks. But at the end of the day, if there's a disagreement, there's a standard on which we have to base these decisions. And it's me that that people need to hear it from, not from my staff. So I get to be the bad guy.
So I'm going to pivot back to a little bit more discussion about supported decision making. In the discussions that we've had in our statewide guardianship committee meetings and discussions we've had in other venues, the Disability Rights Committee for the State Bar Association, the Elder Law and Special Needs section of the State Bar Association, there's some concern about, and perhaps the folks that are listening in will get a clearer picture of that in the next presentation, where there's just going to be a discussion about the functionality of supported decision making. But it is referred to often as an alternative to guardianship, but I think in the way it appears to be functioning, and I would be curious of any experiences you've heard of or had, that it really is, to me, an alternative. Guardianship is you stand in somebody's shoes and you make decisions for them with whatever responsibilities and authorities you've been granted. And in 17A, we know that if you are issuing a decision on the letter of the law, it's plenary, right? There isn't tailoring, there isn't, you can do this, you can't do that, like there is in 81. With supported decision making, there isn't an agent or a person being appointed to stand in the shoes of the individual, but rather, the way I've always described it is you're not standing in their shoes or in front of them, right? You're standing next to them or beside them in an effort to help allow that person the dignity of being able to have their own voice, presuming they have the capability of that in whatever way they may voice or communicate. Have you found that where people have gone either on their own accord or because through the court's evaluation process, you've said, or the court has said, you should consider this might be a better fit for you? Is it working? Do you have any, I guess two questions is A, in your respective areas, and Judge Saul, this is an unfair question to you because you've got Westchester ARC right there. But do you have resources that are local that people can go to at this point for supported decision making, or are you referring everybody back to the pilot? And then I guess question number two is, do you know of circumstances where it's working, where those agreements are actually being accepted and respected by healthcare providers, financial institutions, disability service agencies, and the like? And you may not have an answer to the third one, but I just figured I'd throw it out there. Well, it might not come back to you. So
I have an answer, and it's that we haven't heard that they're not being honored. So that's a good thing. And we are fortunate to have ARC and Nancy handling our matters. But, you know, we're also limited there. Apparently, you know, ARC can only handle so many of these things. And so we're sensitive to that. But yeah, I don't have any feedback on these things not working. I assume it works because it's such a huge push, and we would have heard some, you know, horror stories in our pilot, but it seems to be working well from where I'm sitting.
Judge Gelati?
The only thing I can add is that I've talked to a couple of healthcare providers, executives from healthcare providers who have said, until this Article 82 is fully enacted, in other words, until the regulations come into existence and 90 days passes, and we thus get liability protection for honoring a decision made under an SDM, we're not honoring it. So I think they're waiting to see what happens.
Judge Guy? Thank you, Judge.
Yeah, and I think that's got to be their position. So I think at the lower levels, maybe the day-to-day, in the trenches stuff, there are situations where these kind of arrangements are informally operating, but not many. I think as soon as they go up the ladder, as Judge Gelati says, they're going to get directed to stick with the law. Knowing that SDM NY is interested in expanding its pilot, I would be comfortable referring people to them. I think, and I'm not sure how much of the detail Halden is going to get into in the next session, but I know that part of the regulatory structure that OPWDD would like to include for enactment of the statute is some sort of a framework or a process where every county would have availability of a facilitator or somebody, so every county would have somebody, quote, local that you could work with. You know, that process is going to take some time. And I also think that we have to be, and I think we are, sensitive to the economic and time realities associated with supported, formal supported decision making as compared to a 17A. I mean, we have enough trouble, there are enough challenges to get folks to get 2 affirmations of attorneys dated within a year of getting their application in front of us, and the additional efforts involved in putting an SDM agreement in place may be economically unfeasible, and it may be unfeasible from a time perspective. So I think it's going to take the Westchester counties and the Kings counties and the probably Suffolk and Nassau counties, the more affluent counties, to develop the process a little more before it spreads throughout the state. I do also think there's going to be more educational material that's going to become available. That's going to be part of the kind of the next step for SDMNY New York.
Thank you, Judge. One of the questions that was in the chat that was asked earlier, and it was in the context of our discussion about guardians ad litem and then the pivot to supported decision-making, is, are the facilitators in supported decision-making paid? And I think right now what's happening is the facilitators who are providing services through the pilot is funded. But that funding is coming to an end. And while there's a look for expansion, where it is actually going to show up is unclear. There is some discussion about, because the supported, I should have said this at the very beginning, just in case, I know that judges are aware of this, but if anybody who's attending isn't, supported decision-making, the statute itself, its utility is limited to people, at least right now, to people who have intellectual and developmental disabilities. And it's because that statute is based on the work of the pilot project with that particular population of individuals. It's not for older individuals who have developed dementia or something that's affecting their cognition. It's not for people with traumatic brain injuries that were acquired at age 40. It's not for people with mental health only related disabilities. Again, not yet. And so because it is currently going to be applied only to individuals who have intellectual and developmental disabilities, one of the ways that they're looking at funding, and again, Halden may speak to this later, is having some funds through self-direction be applied towards facilitation, so that there is a funding stream somewhere that would come from someone's budget. If supported decision-making is a process that is appropriate and that individual and their supporters and family members choose to go down that path, or if they're directed down that path. But without that, one of the barriers and one of the concerns that's levied by people who I don't want to say are opposed to the statute, but who are maybe fearful of how it will actually come to pass and concerned about its actual implementation, is that there's not going to be that many facilitators out there. So how long will it take to get through that process if there's only small pockets? If what Judge Guy describes happens, that would be great if we've got it in every county. And you've got people that are trained and able to provide support. There's a disability service organization in Saratoga County that has been consulting with SDM New York, and they have developed their own internal facilitation process that they're working on. It's not, whether or not that's going to be in line with what the regulations say, we don't know yet, but they're at least trying. So there are not formal pilots happening, but informal pilots happening. And those are all people who are, those facilitators are employed by disability service agencies. So not paid directly to be a facilitator per se, that's not your job title, but they're doing it as part of other work they're doing for particular organizations. So probably a long-winded answer, and sorry judges for taking your time with that, but I wanted to just answer that question. And that's one of the concerns about how it will be implemented on a going forward basis, because to say to somebody from Utica, you got to head to Westchester for a supported decision-making consultation, and that's going to take 9 months, and how many times you're going to go back and forth, and maybe Zoom doesn't work for the particular individual that, again, the big one of the philosophies is that it is amorphous because it needs to fit the person, right? There isn't a standard format. There isn't standard subject matter, jurisdiction, or bases for supporting. It's what does this person need? How does it work? How is it going to fit them? Which is both good and bad. The lack of a form, right? The lack of consistency is something that I think as an attorney who can't get financial institutions to accept statutory durable powers of attorney, where we've got a statute that says you got to accept it. I have, I would say, a healthy concern about the availability and the willingness of providers to accept something that looks different depending upon who's prepared it and what that individual has asked for. That doesn't mean we're not going to move forward, but it does create some cause for concern. So the couple of other questions in the chat that are here, judges, because we're near the end of our time here. First was one of the participants asked, and this is sort of pivoting out, but could you comment on resources in your area, if they exist and what they might be, if a family's first language is not English? Judge Stahl, you probably got more of that than.
I was
But I would
hoping
think
I
it
would
too.
go last. You know, I know it's very hard, right? In terms of guardianships, when people come to court and they need an interpreter, we're able to provide them with that. But if someone's going to ARC, it's a lot harder. We're not going to be able to supply that. But certainly in the courthouse on a normal 17A, we do get interpreters.
Judge Gelati or Guy, anything different?
I've had a couple of uneventful hearings involving interpreters, and they've worked well enough.
Yes, that's been my experience too. But in a complicated case, it can be. I mean, one of the advantages of court interpreters is they're familiar with the language that we use and some of the terminology, and that it gets much more difficult if you get outside of the court structure.
Right.
Fortunately, we haven't had many.
Yeah, we see questions about that all the time on the state bar listserv, and you know, just like there's not a lot of guardians ad litem who are willing or educated enough to serve. In the comments you folks were making about to get your 2 physicians affirmations, if you've got one provider, but you've got to make an appointment with another one who's a year out before you know you can get in. That's really common with developmental psychologists and developmental pediatricians, which I don't need to tell you all, you know.
That's the biggest issue we see, Tara, is people struggling to get the second affirmation within the right time frame. Let me also say on the issue of translations in other languages, this issue has come up in the context of Article 81s, and it came to my attention. I can't remember why I got the call, but and we had at the Guardianship Advisory Committee that OCA has, we discussed this kind of generally last month, and there is a project in OCA for plain language forms for Article 81s, and as part of that, there are folks working on translations of those documents. You have to have documentation submitted to the court in English. That's a statutory requirement. But so this issue has come up, and obviously there are more 81s than there are 17As, but this issue is percolating in the context of other guardianship type proceedings.
Thank you. There is I think what will end up being our final question in the chat here that says, do you check out the supporters to be sure that they're going to the right that the individual is going to the right person? So when the determination is there is an alternative to to a 17A that's appropriate, and maybe you suggest advanced directives or your court suggests advanced directives, maybe there's a suggestion or a referral to Supported Decision Making New York or whatever agency may be doing it near you, or perhaps, and I've had this come up in not many cases because of the financial constraints Judge Guy mentioned, but sometimes there's a referral to an 81 that this proceeding would be better brought as an Article 81 as opposed to a 17A. But if once it leaves your court, unless folks come back, it's left your court, correct? There's no follow-up.
Correct.
Yeah. So I think, philosophically, part of the supported decision-making process for this question is that the individual is given the dignity of determining who it is going to be that is going to help them with their residential issues, with their financial issues, with their healthcare decision-making, and they may not go to the right person, right? That's every parent's biggest fear. That's why parents often, one of the most commonly stated reasons for seeking out guardianship is to protect a person, right? They want to continue to advocate, but really they want to ensure some level of protection, some level of limitation of there being any kind of harm based upon their understanding of their child and where their limitations are.
I just want to add something.
Yeah.
So when we send something to supportive decision-making, we're not dismissing the case. We're going to hold it in abeyance to make sure an agreement is reached. And if an agreement's not reached, then it comes back to the court.
I guess your question, Tara, leads me to ask, as you know, when a 17A petition is filed, the court automatically does searches through the Office of Family and Children's Services to see if there's been any indications of abuse or neglect in the past. I guess your question asked me whether or not in the supported decision-making process, our supporters going to have to go through that screening process too.
And I think, Judge, the answer to that is going to be no. There is in the statute, there is a limited class of people, and purposefully to address, I don't know how to say this other than different socioeconomic components. Disability doesn't discriminate, right? Affluency to poverty, it's everywhere. And so in the statute, there is a limitation in certain types of felony convictions, basically, but that's it. Now, if someone has, I agree with you though, if there is a limitation on being a guardian for, if you've had and just because, and this is actually, I think I would ask you, if you've had a case come up where there's a hit, there was a finding in the history of one of these parents of abuse or neglect, do you then automatically say that person is not capable of serving as guardian, or do you do a deeper dive into the circumstances?
A deeper dive.
Deeper dive.
Deeper dive.
Okay.
And if my gut tells me that,
Right.
if my gut tells me that there's a problem, then I appoint a GAL.
It
Got it.
becomes a subjective issue. And, in the same way that there's no restrictions on who can be an agent under power of attorney or healthcare proxy, it only becomes an issue if it gets back in front of a court for some reason or another. I anticipate as supported decision-making agreements will be the same.
Understood. Thank you all. We're at 2:15. I think I got all the questions in the chat. Judges Saul, Gelati, and Judge Guy, thank you so much for your time and participating with us today. We are grateful for it.
We
You're
are.
very
Thank you.
welcome.
Thank
Yes,
you.
indeed.
Thanks
Thank
for the
you, Tara,
opportunity.
Tara
Thank you.
too, because you did a phenomenal job
Yes.
in
Thank you.
facilitating and
Always does.
moderating this presentation. So thank you, all four of you. Wonderful.
Thank you.
Good seeing everybody.
Take care.
Thank
Take
Wonderful.
care.
Thank you,
Safe
judges.
travels, Tara.
Thank you. Yes, safe travels.
Thank you.
Hi, Christy.
All right. We're going to be finished and we have 15 minutes break and then we're going to come back to our next program, which is going to be in 15 minutes. Thank you.